Hi, this is Kaushik Ranchod to you, coming to you live today. What we're going to talk about is DACA. As you may have heard, it's at the Supreme Court. And what is the Supreme Court going to do? Well, it looks like the Supreme Court is favoring, unfortunately, the ending of DACA. It's unknown yet, but the Supreme Court is leaning conservative, and that from the initial feedback has been out there, it appears that the Supreme Court is looking towards ending DACA, but of course we don't know what's going to happen until a final ruling. But I want to make sure that you're prepared in the event that if you're on DACA, what are your options? Well, if you're married to a U.S. citizen or permanent resident and you only have one illegal entry, you may be able to apply for a green card through an I601A waiver. So the way that works is that first an I-130 petition is filed showing that you guys are legally married, that you have a real relationship, and that it's taken a little bit over 6 months as of today. And those times are always changing. They're tending to slow down. Sometimes we're even seeing it take longer than that. And then the next step is filing the I601A waiver. This is the most important part of the actual entire application. So the I601A waiver, that is where you have to just demonstrate extreme hardship. That's not like just mere separation. That's a very high standard. So with extreme hardship, you got to show that if you're a U.S. citizen or permanent resident relative had to go to your home country, or if you were separated, that there would be extreme hardship. So the way that we like to do this is by doing this through a legal brief, making the arguments based off of your specific situation, based off of medical hardship, if that's accurate, or mental health hardship, depending upon whatever your unique situation is. Country conditions. We also look at conditions that may be there for your child, although that your child's not what's called a qualifying relative. That's like a legal term of art, but like your child in and of itself doesn't qualify. But we can look at how that your child's hardship could affect the qualifying relative's hardship and see how all that ties together to create a case. So the extreme hardship is also supported by documentation, because you can't just make assertions. You got to provide documentation that demonstrates the actual hardship. So we work with you on advising on what kind of documents qualify to demonstrate the extreme hardship, and then based off of the documents that support the legal arguments, we submit that together in supporting your I601A waiver. And then the next step, it goes to the NVC. After the I601A is approved, the NVC process is the next step in the process. And that's where you got to demonstrate that you're not going to be a public charge. And that's like the most important part of that NVC process, as well as, of course, completing the DS-260, making sure that you don't have any grounds of inadmissibility. If you do, then you need to talk to a lawyer, because maybe it's not better to move forward with your I601A waiver. And then finally, you have the interview abroad. Now, we always get this question, do I have to go abroad in the I601A waiver? Yes, you do have to go abroad. However, that is only after the I601A waiver is approved. So if the I601A waiver is not approved, then you don't need to go abroad for the final step of the process, and that's where you have the interview before the U.S. Embassy. So that is one very good option for you if you're on DACA, if you do qualify. Another option that could be available to you is 245I. If you had a petition filed for you, a qualifying petition on April 30th, 2001 or earlier, you may qualify for 245I, and you could actually adjust status, file for a green card in the United States. So that's another option. Another option is a U visa, depending upon if you are a victim of a violent crime, and that's violent crime is a term of art. So you should contact our office at 916-613-3553 to see if your violent crime is a qualifying violent crime. You may qualify for a U visa. You also have to have cooperated with the police in that situation. The U visa is taking a very long time. It's taking over 4 years and it's going to continue to slow down, but that's another option for you. So there are options for you if you're on DACA. We don't know what's going to happen. Hopefully DACA will continue to be available, but with the Supreme Court leaning conservative, it doesn't look like that is going to happen. And if you have questions, as always, call us at 916-613-3553. If you have a video that you want me to talk about, a specific area, let me know. Write it in the comments below, or you can call us at 916-613-3553. All right, thank you for joining me today. We will see you next week. Thanks, and have an awesome day.